I don't need to present Greg because you're already known from my presentation this morning. Greg is the mastermind behind this conference and is under jet lag, but nevertheless.
I've had a lot of coffee.
Okay, so thanks to the coffee, why don't you start speaking up?
Great, thank you, and thanks to all of you for helping realize this idea. It's really wonderful. I suspect my co-panelists are going to go into a fair amount of detail on issues that were touched on by panelists in the morning, but I think were not explored in depth, and we thank them for their deference. I'm going to talk about potential grounds for the invalidity of a Ukraine peace agreement that has as one of its central provisions the cession of territory. I assume that it would be a territory currently occupied by Russia, but as other panelists have talked about, we've seen drafts or suggestions that it might include additional territory as well. I'll focus primarily on the argument that such an agreement would be void because it's coerced, but then I'll touch on, which is comes under the umbrella of Article 52 of the Vienna Convention, and then I'll also talk about, to a much lesser extent, an argument that such a treaty might be void because it contravenes a peremptory norm, and that comes under the umbrella of Article 53 of the Vienna Convention. Before I get into those two issues, let me make a couple of preliminary points about the way I think it might be useful to think about these issues of treaty validity. First, if we look at the peace and security architecture that is in theory available in international law and was certainly available at the time the Vienna Convention was being drafted, I think it's hard not to conclude that a peace agreement between two warring parties that has its focus on territory is a second best option. The first best option, envisioned presumably by the drafters of the UN Charter, is that the Security Council would play at least some role in the outcome of such a conflict. Why do I say that the bilateral option or a multilateral option, but not a security-based, a council-based option, would be second best? First, the Security Council could almost certainly replicate most of the facets of a peace agreement. We've seen them do that in Resolution 687 that's ended the Iraq-Kuwait war, that dealt with an entire range of issues, including a final demarcation of the boundary between the two countries. Or if the Security Council doesn't take that kind of maximalist option, it could take a kind of less aggressive option and make clear that there are certain red lines that a peace agreement could not cross, such as ceding territory. Or it could take another approach and order all, presumably under Chapter 7, all UN member states not to recognize territory that is acquired through the fruits of the aggressive use of force. And that would constrain the parties from with the instrument that they could finally negotiate. So the Security Council could probably stand in for the two parties, or the two parties plus whoever else needs to be involved. But they would also have the Security Council being in charge would have the additional benefit of binding everyone else to the terms of that agreement. Now, we could have an argument about whether a final disposition of boundary issues would create an objective regime and be opposable to third states, but I don't think we would have a debate about the finality of a Security Council decision under Chapter 7. So that would be a great world to be in. We're not in that world. The Security Council is not an option. And so what we are left with is other rules of international law that, on their face would seem to stand in for that sort of Security Council action. Rules that, like the ones that Monica and Ingrid talked about on the impermissibility of annexation, and like the ones that I'm about to talk about, the voidness of treaties that contravene those rules. So my point is that to the extent we identify deficiencies in applying these rules, primarily of treaty law, to an agreement which does see territory, that isn't the way it was supposed to be, and shouldn't be the way it is, but it is the world that we are living in. The second point is that in applying those regimes to a peace agreement, and this, I think, underlines points that Asli and Sarah made earlier, we are very much writing on a blank slate. There are very few precedents, both kind of formal precedents and court decisions, or anything you could identify as customary law, or extensive dialogue in diplomatic contexts about invalidating treaties that see territory. The rules in the Vienna Convention themselves are comparatively quite recent. What eventually became the Vienna Convention went through two special rapporteurs before a third special rapporteur introduced the idea of a treaty being void because of coercion. So this is not a principle that's deeply embedded in international law. And finally, we just don't have that many peace agreements to work with. And I'm replicating some data that Asli presented in much more detail, but I'm sure you're all familiar with the fact that almost all conflicts in the post-World War II period have not been international armed conflicts. They've been intrastate and to a lesser extent kind of hybrids. That very small blue band that you see at the bottom of the graph there are IACs, and those are the ones where a treaty in the sense of international law could be applied, and where all of the issues I'm about to talk about would arise. So we have a lack of international armed conflicts, and as a result, we have a lack of final comprehensive peace agreements ending international armed conflicts. And using the PAX data set, and I realize people count things differently. This is data about final comprehensive peace agreements. We have 63 NIAC agreements for the period after the end of the Cold War. And the last time I did this search, which is probably not recently enough, there were only 7 IAC agreements. So we have a paucity of practice, a paucity of experience to draw on. And I think this lack of experience really should cause us to be hesitant about how I don't know if it's heresy to say this to a room of international lawyers, how seriously we should take the rules I'm about to talk about. It's one thing to talk about the rules as principles that have never been tested in practice, but seem to be clear on their face. But when those principles are stacked up against benefits to ignoring them, and we talked in the morning panel about the incentives not to raise treaties of invalidity if that looks like the only solution to a conflict is going to be an agreement that might implicate these issues. Those principles of invalidity might look quite different. This maybe maps the debate about the relevance of General Assembly resolutions to customary international law. It's talk abstracted from practice. But if these principles have to be applied to real life situations where there are tremendous upsides to ignoring them and tremendous downsides to taking them seriously, our interpretation of these principles might look somewhat different. Okay. With that, this kind of preliminary remarks, let me start talking about the law of treaties. I believe it was Oslo who said in the morning session, although it might have been Sarah, I apologize, that we don't have a special body of international law on peace agreements as such. Sarah, thank you. That was not always the case. If you look at international law treatises up until, I think, just before the Second World War, there were quite extensive discussions of peace agreements. And that is because peace agreements in international armed conflict serve quite an important purpose that was separate and apart from, resolving the questions that arose for the particular parties. They signaled to the international community that a period of war had ended, and therefore the specialized rules of international law that were only applicable during wartime had also ended. The most prominent of these was neutrality, but there were a whole series of rules on the suspension or abrogation of treaty relations, how you could treat enemy aliens, how you could treat the property of enemy aliens, whether you could prosecute the people from the other side for war crimes, or what we would now refer to as war crimes. A peace treaty served at the end of a conflict the same role that a declaration of war served at the beginning of the conflict. That signaled that we were now entering the period of peacetime. And for example, if you wanted to be treated as a neutral, you had to say, "I want to be treated as a neutral." We are not in that world anymore either. The application of specialized rules of international law that are applicable only or maybe even partially to armed conflict doesn't turn anymore on formal statements of subjective intent. We are now in a state of war. We are now in a state of peace. The rules are fact based. Do we have an armed conflict or not? Some of them have just those rules have fallen into desuetude, like on the suspension of treaty relations. We now treat peace agreements, for the most part, the way we treat all other treaties. We subject them to the rules in the Vienna Convention, and the rules for invalidating treaties on their face are no different for peace agreements as they are for any other agreements. But of course, the stakes are a lot higher. Okay, what are those grounds for invalidity? The first is the idea of coercion, and this is contained in Article 52 of the Vienna Convention. A treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. One might think, looking at this article, that this is a complete reversal from the, say, 19th century period, when any sort of peace agreement was lawful because the use of coercive force itself was lawful. If there were no fruits of the poisonous tree resulting from force or even annexation, necessarily there were none for treaties. But now we have this rule. As the language indicates, I think that 19th century practice has not been completely reversed. Article 52 does not say all peace agreements are coerced, are void because of coercion. It says they're void if they are used, they are the result of force that violates principles embodied in the Charter of the United Nations. So obviously, a treaty procured by aggressive force would be void, but one could imagine a circumstance where a treaty is the product of lawful force that has been authorized by the Security Council, or force that is undertaken pursuant to self-defense. And Article 52 would not seem to apply to those sorts of circumstances. A number of scholars, some of whom are in this room, have focused on the question of causation in Article 52. And that would seem to be central, right? The treaty is only void if it has been procured by the threat or use of force. And that would seem to require a causal link between the force and the state entering into the agreement. And that is a very difficult question, as a general matter to address. It would seem to involve some sort of psychoanalyzing of the motives for a state entering into a treaty. And of course, we know that states enter into treaties for a whole variety of reasons. Why, for example, do authoritarian states ratify human rights treaties? We can postulate a whole list of reasons and maybe not isolate one as the cause. That is certainly a problem. I don't think it's a problem in the case of Russia, Ukraine. I simply cannot imagine any other reason why Ukraine would, with all understanding what the state and position of Ukraine is today, I cannot imagine under any circumstance Ukraine ratifying a treaty by which it ceded portions of its territory if it was not under the threat of continued force. And if that territory being ceded was not currently occupied by Russia. So I'm not sure, while in theory the causation issue may cause pause in other cases, I don't think it should cause us to pause here. What is more interesting to me than the question of whether this sort of treaty could be subjected to Article 52 is the consequence of doing so. And there are several. And here's where I think we get into the territory of the language of the Vienna Convention and the clear implication of that language not being tested in the real world. The first consequence, and I think someone alluded to this in the morning, is that the provisions that might be void, that is, the provisions on the cession of territory, could not be separated from the rest of the treaty. That is, they couldn't be cherry-picked out and with the rest of the treaty continuing in force. So we have Article 52 and Article 53 specifically mentioned as grounds for voidness that do not permit separation. One could imagine Russia, or perhaps a Russia-allied other party to a treaty, sweetening the pot for Ukraine, offering security guarantees, offering no opposition to EU membership, for example. So there might be things in this treaty that would be extraordinarily beneficial to Ukraine. But as I read Article 44.5, Ukraine could not keep those provisions, but reject the provisions on cession of territory. Secondly, and I think more importantly, whether or not a treaty is void under Article 52 in the first instance is a decision that Ukraine itself needs to make. And the Vienna Convention, in addition to having articles that lay out the substantive grounds for invalidity, has a whole set of procedures about how grounds for invalidity should be treated. And the drafters in the ILC and then again at the treaty conference were quite concerned about frivolous claims of invalidity being raised, and states trying to get out from under treaty obligations that they may have found beneficial initially, but which they found inconvenient at a later time. And so Article 65.1, according to my reading, puts the onus first and foremost on the party that is claiming invalidity to raise the issue. And you can see this language that I've bold-faced here. So it would be up to Ukraine to make the argument that it had been forced. And if Ukraine has the option to say that coercion is a ground for invalidity, it also has the option not to raise that issue. It could keep them up on what seems to me to be a fairly straightforward claim of coercion. And now kind of thinking strategically, wait to see how things develop. If circumstances became more favorable after the agreement was concluded, Ukraine might find it to its advantage to resume fighting. Maybe there is, an economic collapse in Russia. Maybe there is regime change. Maybe there's an inflow of assistance to Ukraine that changes the dynamic on the battlefield. At that point, according to my reading, Ukraine could raise the question of validity and would not be constrained from doing so. And Article 45, in somewhat elliptical language, tells us that Ukraine would not be held to waive or lose that claim of invalidity simply by virtue of the passage of time. I realize there might be other grounds for saying that Ukraine was nonetheless constrained from doing that. You can imagine all of the reliance on Ukraine going along with the treaty, not only on the part of Russia, but on the part of third states. And one could imagine some sort of estoppel argument. But that it seems to me that the Vienna Convention itself doesn't support that sort of argument. And whether Ukraine does that or not is its own political judgment. How am I doing?
Oh, I didn't pay attention. That's a problem. You have to close.
I'll try and be quick.
Close because,
Okay. Time's up.
No, not yet. It is up. Just
okay. Very, very quickly on the second ground under Article 53, a treaty can be invalid by virtue of conflict with a peremptory norm. The problem here is one that I think we discussed in the morning. A peace agreement, if we're going to identify the Cogens norm in conflict as the prohibition on aggressive force, a peace agreement between Russia and Ukraine would not contemplate the aggressive use of force. This is not the Molotov-Ribbentrop agreement, where two states agree to annex or divide up a third state. The most you could say about an agreement that's ceded territory is that it memorializes a prior use of aggressive force and makes concrete something that, in general, the law of state responsibility should say should not stand. There's a couple of responses to this problem, and Ingrid and Monica addressed them this morning. One is that you could say, aggressive that annexation of territory only follows the aggressive use of force, and that the two are essentially indistinguishable. And there is language in the ICJ's OPT opinion where they say that the prohibition of territorial acquisition is a corollary of the prohibition on the use of force. And then the second quotation seems to say that the prohibition on unlawful acquisition of territory is part of the jus ad bellum, which of course regulates the use of force. That's one way to respond. A second way to respond is Monica and Ingrid's perspective, which is that the relevant Cogens norm is the one against annexation, not the unlawful use of force. We had a robust discussion about that. But if you viewed that as a freestanding Cogens norm, then I think the problem might be resolved. Final 30 seconds on this. I think it's important in thinking about how these issues of invalidity would play out to underscore the potential role of 30 states. If all of the issues that have been mooted as significant and important for a peace agreement are in fact included, third states will have to be involved. Think about the issue of frozen Russian assets. Those are held overwhelmingly in Belgium, but also in other European countries, some in the United States, as I think there are some in Japan. If a final agreement is going to either unfreeze those assets or direct them towards a compensation fund, the states in which those assets are sitting would need to be parties. Same thing if there was I know there's that this is a red line. If there was going to be some form of amnesty regarding the ICC warrants, the only way that I understand that could happen is a series of votes before in the Security Council under Article 16 of the Rome Statute, by which the prosecutions will be postponed each year for 1 year, 1 year, 1 year. France and the UK would have to vote in favor of those, and presumably Russia would want them to commit to taking those votes in a peace agreement. So if those third states are necessarily going to be involved, that means they have leverage. They can have a say about what role these grounds for invalidity play. And that, I think, is perhaps one bright spot in an otherwise somewhat bleak legal landscape.
Thank you, Greg. So Dr. Urbanova teaches international law at Charles University and Prague, and your work focuses on accountability progression and international criminal law. I hold an LLM degree from Cambridge and a PhD from Charles University, and we are really happy that you made it despite the Lufthansa strike on a very burdensome travel. So it's really appreciated that you are here. You have to talk for 20 minutes, and I'm going to be a more or less strict timekeeper.
So thank you very much. Thank you very much for your kind invitation. So I have been asked by Florian to talk about the case law concerning invalidity of treaties, but we already heard this true, and there is not yet a representative body of case law concerning invalidity of treaties. But let's talk about what we have. So I would start with case law concerned with interpretation or application of Article 52. The first case I would like to speak about is the Fisheries jurisdiction case, which was decided by the ICJ. It was a dispute between Iceland and the United Kingdom when United Kingdom submitted the case to the ICJ, and it relied on exchange of notes between Iceland and UK as a treaty which conferred the jurisdiction on the court. Iceland objected the jurisdiction of the court, and it claimed that the exchange of notes took place under extremely difficult circumstances when the British Royal Navy had been using force to oppose the official limits established by Iceland. This obviously was a claim which leads to application of Article 52. Unfortunately, Iceland didn't actively participate in the proceedings, which made it quite easy for the United Kingdom government to persuade the court with its line of argumentation. And that proved very detrimental to Iceland's claim on invalidity of exchange of notes, because the court just observed that this probably is like a vague accusation of like a charge of duress, which would render the treaty invalid. But the court also said that it wouldn't like go to such a serious analysis based on such a vague claim, which is unsupported by any evidence. But it's also said the court pointed to negotiations history of the exchange of notes. It said that the negotiation history really like reveals that there was like an absolute freedom of both parties to form their will, and they probably just relied on the British government arguments, because it's quite illustrative to see what the British government claimed. They said essentially they tried to convince the court that the presence of US or UK Navy was lawful. Okay, that's the one element. But the other elements are more like interesting. They also said that the presence of the Navy ended 1 year before the negotiation, before the conclusion of the jurisdictional clause. And then also said that they received many like opposing proposals from the Iceland governments during the negotiations. So court obviously embraced this line of argumentation, and this is quite interesting to see that maybe if like UK, for example, first like conclude a ceasefire agreement, which would lead to a cessation of hostilities, it could like increase the chances of the treaty to survive the Article 52 test, that it wasn't precluded by unlawful use of force. It's a bit clear that God was quite differential to treaty stability, and it set the bar for proving like the causal link between use of force and conclusion of treaty. That threshold seems to be quite high. It was also very severely criticized by the dissenting judge, who disagreed strongly with this approach. He said that we should take into consideration like the reality of the big states and small states, and the big states actually, like United Kingdom, may exercise like a significant pressure without even like resort to actual use of armed force, but that the mere presence can lead to such a coercion that the other state would feel like pressed to conclude the treaty. However, this wasn't the approach that was taken by the majority. To the contrary, like a very different position was taken by Judge Fitzmaurice, who, in a separate opinion, looked into the content of exchange of laws and said, look, actually, the obligations are very, from the exchange of laws, are very balanced. So I don't see any space to think about like a duress. It's also interesting because if you read Article 52, it, to me at least, it speaks more about the process. If the will of a state was procured by unlawful force or not. But he looked into the content. Obviously, it can serve like a direct evidence how the state was like given a space to negotiate really or not. So this is another like takeaway you can have that if the obligations in a treaty are at least somehow balanced, it can also increase the chance that the treaty would survive the test of the validity. Uh, there, another, let's say, decisions were taken in a practice of arbitration tribunals, obviously in a bit easy settings because some of them were given in a dispute between companies and the state. So this is not like interstate disputes. And also the claimed coercion was more of economic nature than of use of force. However, it's a bit illustrative to see their approach because it seems to be very restrictive in leading Article 52. So first case was a case of Aminoil versus Kuwait, where the company claimed to be coerced by the state to make certain concession, and the tribunal said no because what we want to see is that the party to agreement couldn't take any other course of action that it was coerced to do. So this is a quite high threshold for proving it's not like a but or this. It's basically the causal link. This is very high threshold how we've been qualified for modification of treaty. And I would even say that even higher threshold was set up by the tribunal in a dispute between Dubai and Emirate of Sharjah. These two emirates had a dispute over boundary settlements, and Dubai contended that it consented previously with the boundary settlements only because of coercion created by the British government. And they even explicitly referred that the British government allegedly threatened them to locate their ports if they do not consent to the settlement of the boundaries, the boundary settlement. However, once again, the tribunal dismissed these arguments, and it was of the view that it's actually generally during like negotiations of any agreements, there is some pressure present. It is a common element of any negotiation. And regarding the argument on the blockade of Dubai, of the port of Dubai, interestingly, it said that from their experience, it was unlikely that the United Kingdom would eventually resort to force. And this is quite interesting because this is, to me at least, it's like a mere speculation. This Article 52 speaks like, was there a threat of use of force or was there a use of force? And now we speculate, because if we threat someone with a blockade of port, this is like, to me at least, this constitutes a threat of use of force. And now the tribune speculates that that threat wouldn't probably materialize, and uses it as an argument to like for increase like the chances for stability of the treaty. So we can see that the practice of ICJ and one of these tribunals definitely leads to very restricted and very limited reading of Article 52. And it's more differential to treaty stability. We already discussed a little bit the Lusaka Ceasefire Agreement, which was also concluded in a situation of unlawful use of force. It's true that ICJ didn't question the value of the it's true. On the other hand, ICJ also didn't exactly dive into analysis of validity of its agreement. It also like described that agreement as like a modus operandi of parties, which may indicate that it didn't consider Lusaka ceasefire agreement as binding agreement. On the other hand, it's true that in other parts of judgment, it referred to the Lusaka agreement as a treaty. So this was a little bit like unclear approach from the ICJ. But I would just like to say that Lusaka ceasefire agreement may not provide like a safeguard for peace treaty agreement, which would provide for territorial concessions, because it's also true, and I think it played some significant role for the ICJ, that the Lusaka agreement explicitly provided for, it confirmed that the territorial integrity of Congo will stay untouched. So that may be like an important thing to have in mind if you draft any peace agreements on concession of territories that probably couldn't be backed by the Lusaka ceasefire agreement precedents and the armed territories. So one more case I would like to discuss, which a little bit follows what Gregory was talking about, is Nicaragua versus Colombia. It's quite actually a recent case where government of Nicaragua objected validity of treaty concluded between Nicaragua and Colombia in 1928. Obviously, it's a treaty which predates the Vienna Convention. However, that wasn't the biggest issue for the ICJ. They dismissed this claim, but because they were of the opinion that Nicaragua didn't invoke invalidity for more than 50 years, that was the decisive element for the court. And they even came to the conclusion that the treaty, and they explicitly stated that the treaty is valid and in force. And this is quite interesting, because to me there is a difference between if the treaty is valid and in force because the state acts as it is valid for a substantial amount of time, or if a state may lose its right to invoke its invalidity. But the ICJ clearly stated no, the treaty is invalid and is in force, or at least it was in a rule of time. And was impressed by the argument of Nicaragua that at the time of conclusion, Nicaragua was under occupation of the United States. So Nicaragua saw the treaty has been imposed on it by the United States and Colombia, which took an advantage of this occupation in eyes of Nicaragua. And it saw the treaty that it was more reflected like the will of the United States as an occupying power and not Nicaragua. But it lost this case because for 50 years it treated the treaty as valid. And it's true that even in previous disputes with Colombia, Nicaragua already had some disputes with Colombia based on the treaty. It never invoked invalidity in past. It more like challenged the interpretation of the treaty. So we can see in eyes of the ICJ that subsequent state practice concerning the treaty led to a decision that the treaty was considered valid. That was subjected to strong dissent by the studios, who exactly claimed that if a treaty is concluded void ab initio, that it cannot be healed by the subsequent state like this. And I absolutely agree, but majority of the ICJ pressed it down. Also, I believe it was Judge Sima who also pointed to the fact that the court didn't make the distinction between, let's say, some limitations to invoke the right of invalidity, which doesn't lead necessarily to the conclusion that the treaty was valid as itself. There is a distinction which ICJ didn't exactly avoid. So this could serve like a little warning for Ukraine if the Ukraine would rollingly conclude the treaty, which could be, let's say, invalid ab initio. To bear in mind that the right to invoke the invalidity wouldn't be indefinite, and that it can lose this right in a time. So, for example, it seemed that for the court was important the moment when the United States occupation of Nicaragua terminated. So they said, you concluded the treaty in 1928. The United States troops left in 1933. That seems like the moment you should have invoked the validity of the treaty, and you didn't. So I believe that any state who would like to invoke treaty invalidity should bear this in mind. We already discussed the attempts for invocation of Article 53 in context of right to self-determination. It stood that League of Arab States unsuccessfully tried to challenge the Oslo Accords during the advisory opinion procedure before the ICJ, and obviously ICJ didn't rule on invalidity of Oslo Accords, but again, it's obvious from the reading of the advisory opinion first that ICJ also took into consideration that the Oslo Accords didn't provide for annexation and didn't provide for like permanent Israel presence in occupied territory, which made it very different to a treaty which would provide for annexation or permanent presence of foreign troops in territory. Another attempt to invoke a right to self-determination as a peremptory norm was conducted by Portugal in case Portugal against Australia. It was a case which concerned East Timor, where Portugal served as an administrative authority, and it challenged Australia conduct when Australia actually concluded a treaty with Indonesia over exploitation of some territorial, maritime territorial territory of East Timor. So Portugal claimed that essentially Australia violated the Portuguese rights as administrating power, but also that Portugal violated the right to self-determination of the people of East Timor, which could lead to invalidity of the treaty because of Article 3. Unfortunately, ICJ didn't go through merit because they referred to a monetary gold principle and said that they would inevitably have to rule on rights of Indonesia. So they rejected to rule on merit of the case. But we have at least one case where international court ruled on invalidity of treaty because of its conflict with peremptory norm. But it was international human rights tribunal. It was an Inter-American Court of Human Rights. In one case concerning, let's say, one claim against Suriname, it assessed the treaty which essentially provided some obligation connected to slavery regime. So, for example, it concluded like obligations of people to catch and hand it over slaves, or rights to sell some people as slaves. So this is like an obvious violation of use cogens. And that court stated I mean, it wasn't clear whether the treaty was international or not, but it said basically it doesn't matter even if it was international. It couldn't ever be invoked before this court because it would be today essentially invalid as in conflict with territorial norms. So we have one dispute on Article 53. And that's it. I would also like to return to some historical precedents. You already started talking about some treaties concluded in a situation connected to former Yugoslavia, and just few notes about the Kumanovo Agreement. So Kumanovo Agreement was an agreement which was concluded in 1999 in relation to conflict in Kosovo and during the NATO grouping campaign against Yugoslavia. And that agreement was concluded between international special forces and former Federal Republic of Yugoslavia, and provided for some arrangements in relation to Kosovo. First of all, provided for cessation of hostilities, but also withdrawal of Yugoslavian forces from territory of Kosovo, and very importantly, for deployment of KFOR units in Kosovo. So essentially, that constituted the consent of Yugoslavia with presence of international forces in Kosovo. And first, that agreement was concluded during the fellow NATO grouping campaign, which wasn't authorized by Security Council. It was an act of self-defense, so it can be, I think, quite reasonably stated that it was unlawful use of force. And the agreement itself, in the introductory article, explicitly states that in the moment it will be verified that the Yugoslavia complied with its obligations on the agreement, NATO shall suspend its air grouping campaign. I think to me this is like an explicit admission of causal link between unlawful use of force and conclusion of a treaty, which is explicitly admitted even in the text of the treaty itself. But we have seen that the treaty survived. It survived because it was endorsed by the two aides, only because it was endorsed by the Security Council the day after. Otherwise, I cannot imagine how that could survive legally. But I will not get into the Security Council role. It's up to Florian. Just in the end, initially, I didn't intend to speak about Munich Agreement because it's almost a cliche speaking about Munich Agreement coming from Prague. But I will after, because Dr. Korinovich said that Ukraine aimed not to conclude the treaty agreement without Ukraine, and I think that example of Munich Agreement can just support this view and this approach. I would just also say it can serve like a little warning how difficult it's to invoke invalidity of a treaty. In the moment, you have more states involved in the treaty, and not necessarily your state. Just for those who are not obsessed with Czechoslovak history, the Munich Agreement was concluded between United Kingdom, France, Germany, and Italy. Eventually, it led to loss of 30% of Czechoslovakia territory, loss of entire defense system, loss of 60% of whole capacity of Czechoslovakia. And obviously, Czechoslovakia didn't sign any agreement, but signed some subsequent agreements. And I frequently read in academic articles that the signatories held Munich Agreement invalid later, but that's actually not what happened with all states. That was what the Czechoslovak exile government sought, which the declaration of invalidity of Munich Agreement aphasia, and they exerted like a significant diplomatic pressure on all allies to achieve that, even like for example, the entire Operation Anthropoid, which led to assassination of Reinhard Heydrich, was motivated with this goal to persuade the allies that we deserve to nullify the Munich Agreement and to establish Czechoslovakia in pre-Munich borders. But particularly the government of the United Kingdom was quite persistent. From the memoirs of some of our exiled politicians, they claim that Winston Churchill told our president that the UK had concluded so many unjust treaties that if he was about to nullify them, the entire treaty system of the United Kingdom would crumble. But Winston Churchill wasn't exactly a big fan of Munich Agreement from the beginning, that's true. But his stance was more like, we believe that actually Germany destroyed Munich Agreement by their subsequent conduct. And that's what ultimately their decision and their treatment of Munich Agreement. So eventually, the only thing which Czechoslovakia received from the UK was a letter from the Ministry of Foreign Affairs, from Anthony Eden, who confirmed that the UK is of the opinion that the Germany destroyed the territorial arrangement concluded in Munich, and therefore the British government sees itself as free from the obligation from the Munich Agreement. But this is very different. This is a very different stance to nullification of the treaty. This more leads to like a material breach of treaty and termination of the treaty, which obviously there is a very important difference. But this is never easy. For example, you can see even like with France, we were more successful with France because the Czechoslovak government in exile was the first one which quickly recognized the French provisional government in 1944 and was awarded for the recognition with a declaration signed by Charles de Gaulle, which declared the Munich Agreement void ab initio, which was perfect. But then in 1990, after the fall of the communist regime, the Czech government concluded a treaty with France of friendly relations, and once again we insisted on inclusion of the provisional nullification of Munich Agreement. And suddenly the French government was very hesitant. It was supposedly because of their relations with Germany. It was in the time of the unification of Germany also. It played significant role for French government, and they rejected to include such a provision into the treaty. Eventually, the Czech ambassador visited François Mitterrand, and allegedly he told him that he's very sure that the socialist president would like to stay behind the conservative Charles de Gaulle. And the next week, the treaty was concluded with that provision that Munich Agreement was invalid ab initio. But you can see it's not easy to revoke or to invoke invalidity. In a moment, more like states participate in a treaty. So that can serve as a little warning if Ukraine seek to achieve a binding treaty with multiple governments involved. Like we are in Germany, so I can tell you that we negotiated a treaty with Germany, West Germany, in the 70s, and German government asked the Italian government to provide them with the text of the Italian declaration, because Italy declared the Munich Agreement invalid in 1944 ab initio. And it turned out that the Italian government couldn't find the documents in its archives, but they found newspapers called Korea Roma, which published the text of the declaration in 1944. So we have the proof of the Italian declaration from the daily press, which was published in Rome. And we know about it because of the effort of the German government when they see that agreement too. But yes, it is not easy to invoke invalidity. And also, just another little warning, it's we talk about like some legal objections against treaties, and we also talk about how it affects people. And it's true that unjust treaties do affect people. For example, I'm not saying it's completely justified, but today, still, the Munich Agreement definitely resonates in Czech Republic, even more now when in connection with the crisis in Ukraine. And it creates a lot of problems with trust towards some alliances. So it is a proof that like unjust treaty can, cause like very long-term rounds in society. And it's not like a coincidence that most popular quote by far in Czech Republic is Winston Churchill's statement towards Neville Chamberlain when he told him after the Munich Agreement, he told him, "You were given a choice between shame and a war, and you chose dishonor, and you will be given a war." Unfortunately, he never said that, but it's the most famous and popular quote in Czech society. I mean, he never said that, but it's true. It actually, he sent several letters, and he had a speech in Parliament, which basically quote quite fairly summarized. It's true. And there is a lot of truth in this quote, so I'm actually disappointed he didn't say it. But I will say it. I will say that Ukraine didn't choose a war and was given one, but they chose another, and I appreciate it. And I'm very grateful that I can be here today. Thank you.
Dr. Florian Kriener is a senior research fellow here at the Max Planck, and he has also been a second mastermind behind the conference and doing all the work on top. As he's currently pursuing his LLM studies at Yale Law School and works closely together with Harold Coe, whose name has already been mentioned several times here. Julian has written his PhD with Professor Christian Marxen on the topic of peaceful protests under international law. So this concerns also self-determination, democracy, and international law. And you're now working on the topic we're discussing here. And the floor is yours now. Thank you.
Thank you very much, Professor Piers, and thank you, Greg and Kristýna, for teeing up this discussion. As Greg mentioned, the Security Council would theoretically, and from a doctrinal perspective, be in a great position to solve this conflict. And Kristýna has shown why issues of treaty validity, even if they're not perhaps the first things they talk about, will come up eventually all the time. So in my presentation, I want to go into the role of the Security Council in the peace process for Ukraine. And I want to talk quickly about the past action that the Security Council has already taken on this issue, then look at the doctrinal relationship of treaty law and the Security Council powers, and then I will focus on the limits that this charter and international law imposes on the Security Council and talk about those implications for the ongoing peace process. So briefly, on the two resolutions that the Security Council has passed on the Russian aggression against Ukraine, Resolution 2623 of 27th February 2022. If you look at the bottom left corner of the slide, you see there's no operational clauses, and that's because this was not a substantive resolution. It was only passed on to the General Assembly as a procedural resolution. Therefore, there was no veto power that the Russian Federation could invoke here. And that was a resolution that asked the General Assembly to hold a general special session, which it has, and there it has also adopted some 10 resolutions. And then the second resolution, which is also substantive, which has one substantive article, 2774 of last year, on the anniversary of the third anniversary of the Russian aggression, doesn't say much. It says that it calls for a peaceful resolution of the conflict, but then specifically doesn't call this a Russian aggression, but calls it the Russian Federation-Ukraine conflict. And this is very controversial because it obscures the legal nature of the situation which is at hand here. And I think it opens up a pathway, and this is explicitly what both the US government and the Russian government said, that on this basis, the Security Council could have some sort of mediating role. It could be sort of equidistant to both parties. So there is some sort of movement in the Security Council that they would get involved and that they could sort of also endorse or support a treaty process on it. So I think that's why there's a realistic option that the Security Council will be involved, why it's important to talk about its competences and its limits. So if we're thinking about the relationship between treaty law and decisions by the Security Council, there's no explicit resolve within the Vienna Convention or within the United Nations Charter how void treaties will be treated if they are endorsed by the Security Council. The one very explicit provision there is on the relationship is Article 75 of the Vienna Convention, which states that UN action in accordance with the Charter, which goes against an aggressor state, will not be invalid under the Vienna Convention. So if, for example, the Security Council were to take punitive measures against Russia in an aftermath of the conflict, that would not be able to be assessed under Article 52 of the Vienna Convention because of this primacy given there. But for the inverse relationship, so if an article, if an aggressor state concedes this and the Security Council takes action on that, there is no resolve in the text, so we have to sort of rely on structural issues. And there, the general rule is that, according to Article 103 of the UN Charter, there's a prevalence of charter obligations. So if the Security Council takes a decision under Article 25, that is binding upon its members and therefore has to be executed also with primacy over treaty laws. And the Security Council, as we've heard before, has the mandate and also the power to take decisions which would bind its member states. So this is explicit under Chapter 7, and with regard to many of the peace treaties that we've been talking about, most of them have been under Chapter 6. These are, according to Article 25, not binding, but they have a practical value to which I will return soon. So what the Security Council could do, and which it has done before, is that it either endorses or sort of authorizes the peace agreement under its Chapter 6 or Chapter 7 powers. And the most prominent example for this context where it has done so is the so-called package of measures, the Minsk II agreement. So as you can see here from the text, it says it endorses the package of measures for the implementation of the Minsk agreements adopted and signed in Minsk on 12 February 2015. And then in the annex, it includes the entire text of both the first and the second agreement or declaration taken there. And the Minsk Protocol was a non-binding agreement, which was then endorsed, so under Chapter 6 powers, because what I have read is that Russia would have vetoed Chapter 7 use, so it was only under Chapter 6. So one would think initially, because the Minsk package of measures was non-binding and it was only endorsed by the Security Council, this would remain a non-binding resolution to this conflict. But I read the ICJ treatment of this differently, and I will quickly cite from this. This is the provisional measures order given in 2017 in the Ukraine-Russia case for the financing of terrorism and the SURD. And there it writes, and this is the penultimate paragraph in the opinion, the court expects the parties through individual and joint efforts to work for the full implementation of this package of measures in order to achieve a peaceful settlement of the conflict in eastern regions of Ukraine. So there, the court tells the parties to this agreement that they should abide by this, and that this is more than just a non-legal issue, but if the International Court of Justice addresses it, it is to some extent legal. So this endorsement, even if it is only within Chapter 6, has legal relevance, and therefore can also work to legalize or solidify a treaty regime which is either non-binding, as the Minsk measure was, or even if it was a treaty that is invalid. So just to briefly recap this position, the United Nations Security Council can create legal obligations that mirror a treaty by endorsing or annexing it to one of its resolutions. And this would create a separate legal obligation from the treaty obligations. It would be based on the Article 25 powers. And that is very explicit for Chapter 7 measures, but apparently, according to the way I can interpret the ICJ here, also for Chapter 6 measures. And this will then take prevalence over treaty obligations. And based on this, and based on the complicated issues we've heard on Article 52, I think it's not surprising that Russia wants the inclusion of the Security Council on these issues. Because if the Security Council were to endorse or annex a treaty, there would be some sort of legal certainty. There would be legal certainty that this is now a treaty by which everybody has to abide, and there will be no question of in 50 years and 28 years or 30 years, Ukraine being able to invoke its invalidity. And that's why Russia has stated this, although not with the reasoning I'm giving, but I think that's sort of the idea behind this. So that brings me to the question, can the Security Council do this? Could the Security Council endorse a resolution that annexes a peace treaty where substantial parts of Ukrainian territory are handed over to Russia? And in the blog post Professor Peters and I wrote, and on which we've been thinking for some time now, And we argue that the Security Council has substantial limits to these powers. And first of all, the United Nations Security Council, as an organ of the United Nations, is bound by international law, as the ICJ said in its WHO advisory opinion. And this is explicit also in Article 24 of the Charter, which says that the Security Council must act in accordance with the purposes and principles of the United Nations. The principles in Article 2 include territorial integrity and sovereignty. So just taken at face value, you could say the Security Council cannot violate these, period, it can't do anything. But then, of course, there's this inherent tension in the Charter that Chapter 7 allows the Security Council to move beyond most norms of the Charter because of its special powers to create peace. So the question is, how far and under what circumstances can the Security Council derogate from these principles and purposes? And this is the fundamental tension at play here. And one of the issues, which I think is rather uncontroversial, is that the Security Council cannot violate these cogens. What that exactly means, I think, is difficult. My colleague Felix Habert, has a more procedural interpretation of these cogens. We've heard a more substantive interpretation of these cogens today. So I think I can leave the part of these cogens towards the discussion. But the big limitation I want to answer here is that the Security Council may not severely and permanently undermine a member state's sovereignty and or its territorial integrity. And I want to make that argument, give you the reason why I think this is the case, and then also show what that would mean for a Ukraine-Russia peace agreement. So the Security Council is not liberated from international law. It has never opted out of international law, and states, when they acceded to the United Nations Charter, did not want to create a legibus salutis. This is said also by the ICTY in its Tadic judgment, that the Security Council has limited powers, even though it's very potent. And those powers were generally conceived to be immediate and short-term. The idea of a police force from the Security Council is not that the Security Council should be regulating issues all over the world, but it should make specific and very time-sensitive interventions that do not permanently, but issue-wise, resolve a conflict. Of course, the legislative function, if you can call it that way, has grown over the last years, especially also in the creation of the ICTY. But the requirements for that are substantially higher than for the immediate matters. So you have higher material limits. And that sort of background motivates me to interpret this resolution to say that you cannot severely undermine a state's sovereignty, because states did not give up their sovereignty when they entered the United Nations. They still retained a minimum base of their sovereignty, and they wouldn't have commanded the Security Council to abide by the principles of international law through Article 42.2 if they would have given a wholesale sellout of all of their sovereign rights. So the most inherent questions within the state cannot be subject to Security Council move around. And that, for example, includes the question of territory. And we've talked about the Kumanovo resolution. Of course, that's probably the most extreme case. But even in that case, you didn't have the resolution 1244 permanent cessation of territory. You didn't have the recognition of the state of Kosovo. You had an interim administration, that was called at the time, but it was never permanent. There was no idea that the borders of Yugoslavia were being withdrawn through 1244, because all of the states in the Security Council would not have been up for this. They would not have wanted to give this idea, but that's why using the term interim was so important. And the same also is true for the two resolutions that set up the Iraq administration after the 2003 intervention or invasion of Iraq, which is obviously illegal. The Security Council, from a, let's say, a very lay perspective, sanctioned this and said, well, this is okay, and now the US and the UK and who other can sort of interimly administer Iraq. But the language it uses and the way it was framed, the entire mandate, was in a time-sensitive matter, and that this would not permanently dissolve Sultan structures within Iraq, and that Iraq's territory would still permanently be Iraqi. And therefore, from this practice and from the entire reasoning behind how the states integrated into the United Nations Charter and how they constructed the powers of the Security Council, I see, and perhaps we see, that the Security Council cannot severely and permanently undermine member states' sovereignty. So what does this sort of second exception towards the Security Council powers mean for the situation at hand? The Security Council can do many things. It can approve and endorse of many issues in the conflict. It can order a ceasefire. It can affirm the applicability of Russian control over the portions it administers at the moment, and can affirm, for example, that it is the occupying power under humanitarian law, and that sort of entails some obligations, but also some rights at the moment. It can issue a reparations waiver. I think it can also strike up amnesties, because this is not sort of the core of Ukrainian sovereignty at stake here. Where I think the discussion sort of starts is if the Security Council can order Ukrainian neutrality. And I think, for example, if the Security Council were to say Ukraine can have no army, Ukraine cannot have any sensible way of defending itself against a future Russian aggression, I think that would be so invasive towards the essence of Ukraine's sovereignty that this would exceed Security Council powers. And this would be, of course, the same if it forced Ukraine to become part of the military alliance with Russia, which would give Russia the right to always intervene in Ukraine, as, for example, the CSTO alliance would be. And ultimately, the question of territorial transfer. There again, territory, as we've heard time and time again today, is so essential towards the statehood of a country that states would not integrate into the United Nations, knowing that the Security Council could give this away on any aspect, because this would so integrally violate any statehood notion we have. So therefore, in my opinion, if the Security Council would endorse a treaty in which Russia and Ukraine would agree on a territorial concession, that would not be within the Security Council's powers. Of course, it could do that, but that would not have any legal effect, in my opinion. So, concluding thoughts. So first of all, the Security Council is still a relevant avenue and can be very helpful in an early conflict stage. It can create legal certainty on many issues, such as a ceasefire, such as a peace resolution mission, and sort of how occupational rights are being divided. But it can also be a dangerous actor. If, for example, security guarantees are mediated through the Security Council, Russia would retain a veto over these, and then Ukraine could not sort of appeal to neutral security guarantees, would have always Russia on the board. So I think having an overly strong invocation of the Security Council in very substantive aspects can be dangerous. And then my main point is that if a treaty that is sort of concluded between Russia and Ukraine is either non-binding or valid, but still contains very strong concessions on part of Ukraine for essential aspects of its sovereignty, a UN Security Council resolution cannot give this any legal effect, because this would exceed its competences and therefore will be ultra vires. Thank you.
Thank you, Florian.